For legal eagles exclusively. Grammar for legal eagles. Reasonable efforts standard. Teacher's notes from a manual of style for contract drafting by Kenneth A. Adams, 5th edition. 1. How many efforts, endeavours, expressions are there? As many as your imagination may be able to come up with. The most commonly used expressions, though, are best efforts, reasonable efforts, commercially reasonable efforts. 2. What is the difference in meaning between efforts and endeavours? There is no difference whatsoever. In the United States and Canada, drafters prefer the word efforts, but in England they prefer the word endeavours. These words are synonymous. 3. When do contract parties use efforts phrases in contracts? Contract parties use efforts standards when one party wants to obligate the other party to reach a certain goal, but such obligated party has less than full control over the outcome. In other words, the obliged party may be able to reach such a goal, but there is always a possibility that they may fail too. A good example would be an obligation to obtain a permit from the local authority. The obligated party may duly file the required documents, and yet the local authority may refuse to grant the permit sought. Adams 8.4. 4. Are the efforts clauses enforceable? Yes, courts in most US jurisdictions have held that efforts provisions are enforceable. However, the Illinois courts differ slightly in this respect, as they have held that a promise to use best efforts is too vague to be binding if the parties fail to articulate what performance the phrase requires. Hence, an efforts clause under Illinois law must provide for a procedure to evaluate whether the required behavior under the efforts clause has been demonstrated. Adams 8.20. Interestingly, a US court has held that an obligation to use best efforts to reach agreement is equivalent to an obligation to negotiate in good faith. 5. Is there a hierarchy of efforts standards? According to Adams 8.2, although many commentators accept the notion that there is a hierarchy of efforts standards in the USA, this is merely anecdotal evidence. US courts have consistently refused to follow any differences in meaning between the numerous variants of this expression. 6. Where does the belief in the efforts hierarchy come from? A number of corporate bodies have published guidelines on using efforts standards. For instance, the American Bar Association Committee on Mergers and Acquisitions has noted that there is a general sense of hierarchy of various types of efforts clauses that may be employed, Adams 8.25, namely starting from the strongest: best efforts, reasonable best efforts, reasonable efforts, commercially reasonable efforts, and good faith efforts. 7. Do the courts recognize such anecdotal efforts standards hierarchy? It depends on the jurisdiction. In the United States, both the courts and the Uniform Commercial Code have declined to recognize a hierarchy of efforts standards. On the contrary, courts in England and Canada have endorsed this notion. For example, in Canada, a best efforts phrase imposes a higher obligation than a reasonable efforts phrase. Adams 8.60. 8. Is the efforts standards hierarchy workable? According to Adams 8.79, the efforts standards hierarchy is unworkable, mostly because imposing an obligation to act more than reasonably is unreasonable. In other words, requiring the contract party to act more than reasonably creates too much uncertainty as to what level of effort is required. 9. What is Adams' advice on drafting efforts clauses then? 1. Be precise instead of vague. Because effort standards are vague, they can lead to a dispute and unpredictable outcomes at trial. 2. Use efforts provisions only if the party in question doesn't have complete control over whether it can achieve the required goal. 3. Use only the reasonable efforts standard. Set standards for measuring performance. Imposing an obligation to use reasonable efforts to sell, for example, widgets, doesn't make sense unless you indicate how many widgets must be sold and how quickly, or imposing an obligation to use reasonable efforts to file a registration statement doesn't make sense unless you include an indication of how soon it must be filed. Adams 8.1-39. 4. Define reasonable efforts standard. For example, reasonable efforts means, regarding conduct by a party, the efforts that a reasonable person in the position of that party would use to engage in that conduct competently and promptly. Adams 8.156. For legal eagles exclusively. Thank you.